Come to learn laws, where knowledge is power, not legal advice, just for education. Need real counsel, don't roll the dice, always speak with a licensed attorney.
Welcome to Learn Laws. We're here another week, another day. Today, we're going to be talking about the business judgment rule. So this is very near and dear to my heart, and I wish I would have known about this rule, when I was younger. I think the biggest problem with entrepreneurs, any kind of entrepreneur, small business owner, anybody with a little bit of hustle, they start these businesses and they get scared, they get nervous to make any kind of business decisions, right? So, for instance, in my case, when I started my first company, or my first, what I call, investor-backed company back in 2006 or 7, I raised a bunch of money. And, when you're a CEO of a company with investors, you have to make decisions, right? And sometimes it's really hard to make those decisions because you have to balance those decisions with the fact that you're going to need more money from your investors, because eventually that money runs out with your R&D and trying to build a scalable venture. So you have to balance the business judgment with the need for investor capital. And then you also have to balance that with a bunch of legal risks, right? Because if somebody invests money in your company, or if you engage in kind of like business partnerships or something like that, these rules are very important to understand, because this will allow you to make more informed decisions and not be scared to make those decisions. So in my case, I was very scared. Every decision I had to make, when I first met you, 15, 16 years ago now, I remember you didn't know what the business judgment rule was, because you weren't an attorney yet. You were just a young entrepreneur. And I would always stress out about the decisions, and all these different scenarios would play out in my mind. Okay, well, if I make this decision, what are the consequences of that decision? What kind of liability am I going to have personally as an individual, but also as a company trying to keep my company afloat? So that's why I thought this episode today would be super important. And I highly encourage anybody listening to this podcast to watch to the very end, because this is information that is going to probably help you make really good decisions, and also prevent a lot of liability and take the drama out of it, right? So when you do make a decision and you get some flack from either shareholders or business partners, you can feel confident in knowing that you've done the right thing and that the legal liabilities are limited. So that brings me to my first question today. What is the business judgment rule, and why is it important for small businesses?
Yeah, so the business judgment rule is a statutory and common law presumption that basically, as long as you haven't been doing something deliberately against the best interests of the company or in bad faith, the presumption is that you're making a decision that you think is in the best interests of the company, and therefore in the best interests of the equity and shareholders.
Okay, so for instance, if I'm making, let me give you an example here. So I'm saying, hey, I think it's in the best interest of the company to cancel the contract.
Yeah.
That would generally be protected under the business judgment rule.
Yeah, so we need to know what kind of contract it is.
Yeah.
But in general, if you're making a decision, let's say as a director,
yeah,
right, and you think, well, this contract is garbage for the company, and there's no need for us to continue it, and maybe you didn't see something of where it was going to provide you value, right? Maybe you didn't realize that next year it was going to be a patent that was going to be in high demand, like the screen protector glass, right?
Yeah.
So in that situation, of course, you're using what information you have available to you and acting in good faith in the best prudent interests of the company to make that decision. And maybe that decision was a wrong one. Maybe you even admit that it was wrong at the time in hindsight.
Yeah,
right?
like gross negligence or something like that. Like it was just negligent.
Well, I mean, there's negligence, and then there's gross negligence, and then there's willful misconduct.
Okay.
Right?
Yeah.
So at the very bottom, when we talk about negligence, we're talking about you have a duty. You've breached that duty. That breach of the duty has caused some kind of damage to the company, and therefore you're liable. Okay, so that's really just like the solid basis for negligence claims. You're talking usually a lot of personal injury cases, that kind of stuff. That's the statutory threshold. Okay, so the business judgment rule says you're not going to be liable for negligence that way. Okay, as long as you're not breaching any of your fiduciary duties, like duty of care, duty of good faith, fair dealing, and you're acting as a reasonable, prudent person would in that circumstance, you're not going to be liable for negligence. And for corporations, you're not going to be liable for gross negligence.
Interesting.
Right?
Yeah.
So now that's the general rule, and there's been some new modifications and scholarly debate on trying to adjust that because we have a full spectrum of situations that can occur in a corporate environment, right?
Of course.
On one side, we have somebody who's acting in good faith and does their research and thinks that they're making the right decision for the company, and it ends up being the absolute worst decision for the company altogether. Maybe you're Blockbuster and you think, wow, people are really going to, continue using us for a long period of time. We're going to be the classic, retro place to go. And we don't need to do video streaming like Netflix. We don't need to acquire that, right? Everybody in the hindsight says, wow, Blockbuster did a bad thing.
Yeah, we should have acquired that.
We should have acquired it, right? But so you have that side of things where it's really innocent mistakes, essentially.
Yeah, they just chose that they thought it wasn't a good business decision at the time. They thought, well, the traditional brick and mortar model will be around forever.
Right.
And then why would we do streaming service? It doesn't make any sense because who's going to...
That's just a fad. That'll go away. Everybody's going to still do it, right? So we have the business judgment rule was designed to protect those people, the people who are running those businesses, who are making those decisions in good faith. Maybe we're not the right people for that position, but at least they're not going to be personally liable for having made a bad decision that ended up resulting in a lower valuation of shares for their shareholders. Then on the other side of the spectrum, we have the Enron, right?
Yeah.
And we have a situation where people who are managing a business, knowing that they're doing bad things, knowing that they're doing things in bad faith and are going to devalue the shares in the long run because of their fraud, their misrepresentation, because of the bad decisions that they're making, maybe even self-dealing and things like that. And so the business judgment rule ended up being this blanket protection for both sides of that spectrum. And the Congress said, well, we probably want to pull back a little bit on this side, the Enron side, and hold directors and officers a little bit more liable. So they came out with the Sarbanes-Oxley Act to try and combat that potential problem, right, of covering up somebody's protection, because it is a burden.
Yeah,
right? When we talk about the business judgment rule in application, what it means is if I am a shareholder and I want to sue you as an officer or a director, I have to overcome the presumption that you did the right thing and that you were acting in good faith and that you did your research and you just happened to make a bad mistake, right? Not that you had an intent
to do it. So it's all about intent, really.
Right.
So you mentioned something about self-dealing. I just want to bring this topic up. I don't mean to interrupt you.
Yeah.
Can you give me an example of self-dealing? Because I'm thinking of self-dealing as, I think in a modern sense, entrepreneurs, especially, again, I from an American-based person, right? We tend to have a lot of different ventures. So like I have a real estate business, right? And then I have an online education business that I co-founded with you. And then you have your law firm. And, we do all these different other deals with other people, right? And so how do you prevent like self-dealing? I think that's so broad, right? Because what's the definition of like self-dealing? And can you give me an example of what would be self-dealing, what would be okay? And let me go back, let me frame it in the right way. Like if you look at a guy like Elon Musk, right? Super popular guy, super good at what he does. And maybe people are looking the other way because he's making them so much money. Maybe that's the case. But he has like SpaceX, which is not part of Tesla. Then he has Tesla. Then he has the Boring Company. And then he has Starlink. Now, all these companies aren't necessarily part of Tesla. Tesla is the battery company, maybe AI, maybe car making company. So would that be classified as self-dealing in that sense? Or is there just another kind of idea you can give me what self-dealing would actually entail?
Yeah. So let's actually talk about that. So I think Elon Musk is probably a really good example to use for self-dealing. So self-dealing is the corollary to the duty of loyalty, right? As a director or officer of a company, running a company, the shareholders are entrusting you to make decisions that are in the best interest of them, not you, right? That's what we call the duty of loyalty. If an opportunity presents itself to you, let's say NASA comes to SpaceX and says, hey, we want you to develop technology for us to be able to mine asteroids that are coming to near Earth orbit. Okay. if they go to SpaceX and provide SpaceX that opportunity, or maybe they go directly to Elon Musk, he now has the opportunity to say, okay, well, which company that I'm associated with that I have a fiduciary duty of loyalty to, should I be presenting this opportunity to, right? Should I be bringing it to the Boring Company because it has mining technology already? Should I be bringing it to SpaceX because it's going to involve a space component and would be consistent with that particular aspect of the business? Or what happens if I decide to start up a brand new company that I've given the opportunity? Given the opportunity. I'm the sole shareholder now, and I accept that opportunity and take on that contract through a brand new company that has no shareholders. In that final scenario, that's probably a pretty big usurpation of that opportunity or breach of
because he owns 100% of the company. It benefits him completely. And maybe with, how you get around self-dealing in that aspect, right? I would think would be, so you have Tesla, which is the main public company with all the, I would assume, millions of investors at this point, right? Probably quite a few. And so I think because he can deliver the services from SpaceX or Starlink to the Tesla vehicles, if that's what he's doing, because he can deliver cheaper, that business judgment rules, hey, even though I'm a shareholder of this company, I'm benefiting from this contract. I'm actually benefiting the shareholders more at Tesla because we're doing it at a cheaper rate, and so forth. Is that how you kind of make those decisions?
Yeah. So I want to slice the bread here to make sure we're getting the right definitions.
Yes.
Okay. So we're talking about duty of loyalty. Loyalty says, hey, if you're given an opportunity, you have an obligation to present it to the company that you have fiduciaries to, and give them an opportunity to choose to accept it or not accept it. If you bring it to them and say, listen, this is too far outside of the scope of the Boring Company, or this is too far outside of the scope of what we want to do with SpaceX, so you can have it.
Okay.
Then of course you've met your obligations. You want to spin off a new company to do the technology. You've met your obligations. There's no issues. Okay. When we're talking about self-dealing, now we're talking about a situation where maybe you get that opportunity. SpaceX says, yeah, we're going to bite on this, right? We want to be a part of this technology. We want to be on this contract. Let's do it. And then they turn around and Elon says, okay, cool. Let's sub out the work to this other company, ABC, technologies.
Yeah.
Okay. And what they don't realize is that he's the sole shareholder of ABC Technologies, and he's making all that revenue. And now basically he hasn't disclosed to the shareholders and in compliance with his duty of candor to them that, hey, I'm going to be making tons of money on the side from this too, because I'm going to be being paid by the company that I'm also getting paid for to do their best interest.
Okay, that makes a lot of sense.
That's the breach of the duty of self-dealing.
Okay, and what's candor? Because I feel like that's a term that I understand a little bit, I guess. But what would that duty be, the duty of candor?
It's about being honest and upfront, right?
So you're just transparent, essentially.
Being transparent, right?
Fully transparent.
Anything that you think any reasonable shareholder would want to know about any particular type of deal, or might be material to the transaction or material to understanding whether or not you've met your duties, is something you should be disclosing.
And I think it's always important to be as fully transparent as possible, especially when you're dealing with other people's money, right? Because people sometimes go down a place, especially if you go through hard economic times where the company loses a lot of value, or you have some catastrophic event that, really puts the company at risk. People start getting weird when they start losing money. In my experience,
I mean, people can get weird when you're making money.
Yeah, I mean,
you're not making enough.
Yeah, I mean, you look at. Here's Elon Musk is a perfect example. Look at that. I think it was a derivative suit. They bought like 5 shares or a share, and then they sued him over his compensation package. Right. I mean, that's a perfect example. The company's doing well. He's making money for a lot of people. He made an agreement beforehand, and people are still trying to sue him because they think like he's making too much money, even though nobody would have money if it wasn't for him.
Right.
But I think the key takeaway there would be just try and be fully transparent, right? And if you're making a decision and you feel like shareholders are going to have a problem, or if they have a problem, maybe walk them through the process of how you made that decision. And I guess that brings me to the next question: is how would you document these decisions? Because I think that probably from a just from a legal perspective, documenting how you made these decisions is probably pretty important, because you can go back and do like an autopsy of the decision and figure out what went wrong.
Yeah, absolutely.
Or what went right.
Yeah. So directors have a certain level of fiduciary, and officers have another level of fiduciary that's kind of added on to what the directors have. So on the officer side of things, not only do they have to have good faith and work as a prudent person normally would, but also they have to follow the rules, right?
Yeah.
If you're an officer, you're an employee of the company, and you have a fiduciary to follow the rules that the shareholders have have provided for you. So there's bylaws, there's resolutions that have to be made. There's maybe limits on what kind of contract you can bid on without presenting
Policies and procedures.
policies and procedures.
So that's
right?
why it's so important to
You gotta
document policies.
you bring it in, into a meeting, maybe have a meeting of the directors and say, hey, we've got this big opportunity. NASA wants to give us this contract. Is this something we want to do, et cetera, right? So as an officer in particular, you have to not only follow the same rules for fiduciary, but you now also have to make sure that you're following the corporate compliance aspect
Side of it.
and making sure you're following the policies and procedures the company's provided for you to make sure you're not breaking any duties there.
So I guess if you're the sole shareholder, like if you're a single member LLC, you're probably not going to have to worry about the business judgment rule because who's going to sue you? You're not going to sue yourself, right? So I think that's where a lot of entrepreneurs, when they're scaling, they go from like a single entity, maybe like 1 or 2 shareholders, and they don't really worry about it too much.
Well, for most people, you're absolutely right. Right. If you're a sole member, you're never going to have a derivative suit against you.
Yeah.
Right. If you're the sole shareholder, you're not going to have a derivative suit against you unless you get sued personally, and then a creditor takes your place in your shares, but you keep your job.
So
right?
then once they take their place, once they step in your shoes, right, then they could come after you. So I guess it's always important to document everything. Even if you're a single member LLC, you're 100% shareholder in your incorporated business, or whatever business legal entity. Question for you. So to document the decisions, if you have shareholders, you would want to have some sort of study, maybe. Again, I think that I don't want to be so cumbersome with when people are watching this, because I don't want people to get turned off of saying, hey, well, this is just a lot of work. So what are some simple ways people can document these decisions, whether you have shareholders, you're a single member LLC, or you're just 100% shareholder in your incorporated company?
Yeah. So what you want to do is make sure that anytime there's a question, right? If you're starting to think and ask yourself these kinds of questions, is this something that I probably should bring up to the other shareholders or to the directors? Is this something that I should present and give them an opportunity to review? Just do it. Right? Actually just present it. It's going to look much worse for you if you do a lot of things without ever consulting the other side.
Yeah. And I think most people, in my experience anyways, right? So, I had a venture capital company I started when I think it was like 22 or so. I can't believe I started so young. I mean, I look back now and I'm like, oh my God, like who would have, invested in me right at that point? But would I invested in myself? Maybe not, right?
People were investing in Puma, right?
It was crazy, yeah. It was really crazy. So I think the key for me is I've never been sued by a shareholder, ever, right? So I think that's really important. And the reason why I brought that up is because, it happens all the time for good reasons or non-good reasons. But I say that because I was fully transparent, right? Like I had a proper offering document. My goal wasn't to raise money. So, and I think a lot of people, when they're raising money or scaling their business and bringing out outside partners or investors, they just say whatever they need to say to get the money, not realizing the consequences in the end. And I've seen this in the venture capital industry, private equity, whatever you want to call it, private credit industry, where they're trying to raise money from the public or whatever. And they just make all these like misrepresentations or, like kind of cross the line of the gray area. And I think the reason why even though my business struggled in 2008 and I ended up selling it at a loss to some current officers and directors and shareholders, being fully transparent was, I think, the key to my success and comeback too, right? Because I was fully transparent. Investors knew what they were investing in. You have to clearly be, and again, if somebody's scared to invest in you after telling them, trying to be fully transparent, maybe that's a good thing, right? Because you don't want to be losing people's money that always were nervous to invest anyways. You want people that actually know what they're investing in.
Yeah, I mean, what do they say? Sunlight is the best sanitizer,
yes.
right?
That's correct.
So
yes,
definitely. Even if you're embarrassed to bring it up, if it was a bad decision, definitely disclose it, right? Madoff got into that problem, right? He made a mistake. He had a reputation for being this amazing superstar.
Yeah, that's a weird
who
situation.
Never lost money on investments.
Yeah.
And then he started.
Well, he did lose money on investments, but
at the time, right?
Yeah.
He had a reputation that he was this all-star,
that's crazy,
right? And suddenly he had an investment that was going really bad,
and he thought he could cover it up.
And he thought he didn't need to disclose it to his people because I'll just make it up on the next one.
And then that's
the
what started the
next one.
Ponzi scheme. And then years and years and years of all these bad deals, or just trying to cover it up and never making it back. And that's where, when the economy gets rough, the saying goes, you'll see the naked swimmers, right? Because the water starts flowing out. And I think in a booming economy where you have easy credit, you have lots of money, people are doing really well, people don't, I guess, they just don't think about things like that, right? But I think it's really important to, understand what you're doing, be fully transparent, and again, deal with situations. If you're fearful of those situations, look it straight in the eye of that fear and say, I'm not fearful anymore, and trying to overcome it. Does that make sense?
Yeah. And so circling back on, making sure you're not afraid.
Yeah.
A confused mind is always going to say no. So
Yes.
if you don't understand a deal and you're
Yes.
a director or you're an officer
Yes.
of a company,
Yes.
maybe say no.
Yeah, my mom was confused about 30 seconds ago, but we fixed it up now. I was trying to think about, yes, anyways.
Yeah. So, obviously, understanding a particular topic is incredibly important
Yes.
for getting this business judgment rule
Yes.
on your side. Right?
So what
And
is-
if you don't understand, but you still feel like maybe it's still going to be in the best interest of the company to move forward, get an expert. Consult somebody else that really does understand it and makes a lot of sense. Bring them into a meeting of directors or a meeting of officers, and have them provide a presentation on the details and why it's a good decision for your business or such a bad decision, so that you guys can make an informed decision. Which is the standard under officer liability for getting the benefit of the business judgment rule.
So is that where opinion letters come in? Because I would assume that's what a lot of opinion letters are for, right? Hey, I have this idea. I want an opinion on whether it's legal, and whether it's feasible, and maybe you have a feasibility study, right? And I would assume that's why companies, especially these large Fortune 500 companies, spend so much money on these legal opinions and these, feasibility studies, is because they need to protect themselves from that liability.
Right. I mean, how nice is it if a shareholder comes back and says, you know what, you made a terrible decision in the past. My shares are now completely devalued because of a decision you made. You can turn around and say, well, listen, I made that decision in good faith, and you know how I can prove it? I brought in an expert who's supposed to know better, right? Who knows more than anybody else on the board or anybody in the C-suite.
Yeah.
And they gave a presentation. Here's a copy of the presentation they gave us.
Yeah.
We sat there for 3 hours asking them questions, drilling it down, trying to understand the potential consequences and benefits of this decision. And we all voted to either move forward or not move forward with it. And, it was we used it in good faith, and it didn't work out, or it did work out. Either way, you're not going to be liable under the business judgment rule just for that.
Now, I know we're talking, or we're speaking in the context of, having shareholders, but this applies to people with like single member LLCs, or people with 100% of their own shares, their own private company, and, not to let their guard down, because sometimes, like you just said earlier, if something ever happens, say your business goes into bankruptcy, or you get sued by a creditor, and they, somehow are able to step into your shoes by taking over either the membership interest somehow, or the taking the shares and then stepping in your shoes, then they're going to come after you as an officer. So it's really important in the context of raising money and having investors to follow these rules and make sure you document everything. But also from a private member LLC or private company, it's also important to document this stuff too, in case something ever happens. Now, the likelihood, I think personally, of something like that happening, in my personal opinion, is probably rare, especially if you're the single member LLC owner or multi-member, or maybe two members. Well, I guess if you have two members.
Yeah. So let's start talking about some of the different applications
sure.
and the standards and how
would be
things
good.
would work, right? So the business judgment rule traditionally grew out of a corporation, right? It was something that was applicable to directors of corporations that then came and got extended to officers with a slightly modified standard. And then they started applying it to other things, right? Now we say nonprofit corporations also can get the benefit of the business judgment rule, and then LLCs as well. So you've got a variety of potential scenarios that could be involved when we're talking about a business judgment rule, but the standard that gets applied in each one of those scenarios may be varied a little bit. But when we're talking about applying the standard itself, we want to make sure that you understand that there's some situations where it's going to be common sense, right?
Of course, yeah.
Either this was a blatant violation of good faith, or this was, hey, we did our best and unfortunately it didn't work out, right? So, and then, obviously there's going to be some really confusing in between places. And so the trend now is that in complex business disputes, where there's multiple moving parts coming in and out, they're trying less and less to apply the business judgment rule. So if it's a really super complicated deal with 20 different moving parts and subcontracts and things like that, then they're just going to say, you know what, we need to kind of go drill down at the facts rather than trying to apply this presumption before we move in.
So instead of trying to apply the presumption on a very, broad spectrum, they drill down and say each individual decision, or how would that work when they drill down?
Yeah, so when they drill down on a complex business case, right, there may be, let's say, 20 different decisions that you had to make, and the shareholder is trying to sue you saying that you made a bad faith decision on all 20 decisions. Mm-hmm. And in reality, maybe we need to look at the evidence and discovery to make sure, and by the end of things, you might find out that there were 3 decisions that were done in bad faith and 17 that were not, right? And so the question is, should we be applying this larger presumption of a business judgment rule across the board for all 20 things, whereas we still have these 3 situations that could have overcome the presumption in the beginning? So instead of trying to suss out, and address through a trial of all of these individual things at once, and then potentially missing these 3 issues, we're going to just hold back on the application of business judgment rule, maybe rely more on the Sarbanes-Oxley, which is the counterpoint of it, to try and get a little bit more into the details.
So that would be like the plaintiff's burden, right? When they're coming after you, that's their burden to prove that you, in fact, were self-dealing or you had bad intent or ill will or something along those lines, correct?
Yeah.
Okay.
So it's up to the plaintiff to overcome the presumption that you made a good business judgment as long as you didn't breach any of your fiduciary duties while you did it.
Okay, so that brings me to my next question. What decisions aren't protected?
Yeah. So things that are not protected or accepted from these kinds of things are self-dealing.
Yeah.
Right? Done in bad faith. Let's say we're talking about that situation you were talking about earlier where you have a creditor.
Yeah.
And you've got your own business, and let's say you're, manufacturing widgets. You might have made a contract with your brother to sell those widgets for 10% of cost, right?
Yep.
And basically bankrupt the business in so doing. Then your creditor comes in your bankruptcy and stands in your shoes and takes over your shares, which is something that they are permitted to do.
And that happens all the time, right?
I mean, not quite all the time, but
Yeah.
It is something that they can do. And so when they come in and stand in the shoes of the shareholder, they get all the rights that the shareholder had.
Oh, wow.
Including rights to sue for breaches of fiduciary duty. And so handing off a contract to your brother for 10% of the cost is a breach of good faith, right? You knew or should have known that was going to bankrupt the company by, creating this contract to give all these widgets away for below cost. Right?
That is so interesting.
And then that creditor could then, potentially win. Now, when it comes to the business judgment rule, there's another important distinction that you should be aware of, which is it's only going to be applicable to damages. Okay.
So it's only monetary, so it's not criminal.
Right. So in that kind of situation, they're going to be able to go after maybe the loss in share value as a result of the breach, or maybe the loss of monetary value as a result, right? Each state is going to interpret it a little bit differently and apply a different standard. But it does not apply to injunctive relief. So, for example, back to that situation where you're manufacturing widgets and you do this contract, a shareholder might have discovered that contract that you did, and then ask the court to say, we need to stay that contract because it was done unlawfully, or maybe it was a breach of our fiduciary.
Okay. Yeah.
So we're going to force the company to stop performing under that contract because it's going to run us to the ground. And in that situation, that business judgment rule will not apply.
So like this, I know we keep bringing up like a guy like Elon Musk, right? Because he's almost like a Trump, where they have so many new so many new things that they're like precedents or just precedent setting people, right? So for Elon Musk, when they had the compensation structure in Delaware, where they basically washed, even though the shareholders voted on it, even though everybody agreed on it, and it was all his stuff was performed, his everything he said he would performed. He got his stock options. Somebody sued him in court. Obviously, the judge basically nixed the deal, which is crazy to me. At this point, if anybody decides to incorporate their company in Delaware, if anybody suggests that as an attorney, I think personally that's like malpractice, right? Based on all the precedents that are coming out of Delaware. Obviously, that's attorney specific, but I personally would not incorporate or form a company in Delaware at all. And then I guess they had another shareholder vote.
I certainly would agree that the reputation of Delaware was diminished.
Big time, yeah. I mean, if you have a company that's incorporated or an LLC or whatever in Delaware, and the majority of shareholders, according to your bylaws, agree on a certain compensation package for a CEO or a director, officer, employee, whatever, and some random judge says, no, I'm going to invalidate this, and then you have another vote and the voters again reaffirm that this was the proper compensation package, and then the judge again says no, that's really weird to me. That does not make any sense.
I mean, that the idea is if you're following the corporate compliance, you're presenting these kinds of large deals to the shareholders, and if they approve it, you would think that as long as it's in the best interest of the company, it's going to work out.
It's really crazy.
And you can trust it. So certainly was surprising to quite a lot of us in the business law field.
So yeah, I remember we talked about that. We're like, this is crazy. What's going on here? So I guess we already talked about this, but can you give me the 3 or 4 things that directors and officers can use to avoid breaking that fiduciary duty?
Yeah. So obviously we want to make sure that if you're in a position that you know all about the topic of this decision beforehand, okay, then you have to use that knowledge in a prudent way to make sure you're making the right decisions for the company. You should be doing this in good faith and make sure that you have care for that particular transaction and that you're not breaching any other fiduciary duties that you have in the meantime, right? So if you know that you're going to make money from this transaction separate from your compensation as an officer or director, then you need to disclose it. And if you disclose it and they say, well, we don't want you to make money off this transaction, then you should not be making money.
Of course. Of course.
Or maybe they're just going to say no because this is crazy that you're going to be making all this money off of something that you're already getting paid to do.
So that brings me to my next question. So I guess, is there a fine line between the business judgment rule and being liable for monetary damages and then fraud? Or are those two kind of are they both together? Does that make sense? Because I think that a lot of small business owners, when they're listening to this, or entrepreneurs or whoever's listening to this, when they think about, okay, well, I'm self-dealing, would that be considered a fraud?
Well, okay, so fraud is something that can come into play when we're making these types of claims. But let's be clear, fraud is not something that you can hide behind the business judgment rule behind.
Okay.
Okay. So the business judgment rule is only going to protect you if you've worked in good faith, right? So fraud is bad faith, right?
Okay.
Fraud is something that's going to have to be pled by the shareholder specifically, which means they can't just say, I know James is out there defrauding people and I don't know the specifics. I don't know how he's doing it, but he's definitely making money off of this.
So there has to be specific.
They'd have to say, well, James is the owner of ABC Company, and ABC Company just got a contract from the company that he's this officer for, and now he's going to be making all of this money without having disclosed that to the shareholders to make a decision.
Ah, okay. So that's the difference. Okay. So it's all about, really disclose, even when in doubt, disclose.
Right. And also use a little bit of common sense.
Yeah, of
right.
course.
If it's stinky, if it sounds weird, if it sounds like fraud or misrepresentation, talk to an attorney.
Yeah,
get some advice.
If it sounds too good to be true, it's probably too good to be true, right? If that makes sense. So, when should directors and officers call counsel? Because I think this happens all the time. Say you're a C-suite executive, you're just a high-level manager in an entity or a company, and you're making these decisions. When should those people talk to either the general counsel at the company or obtain legal counsel? And should they obtain legal counsel separately from the company's legal counsel, or can they rely on that company's legal counsel to make those business decisions?
Yeah, that's an excellent question. So there's a couple of things I want to unpack about that. So number one, when you are an officer of the company, you have a standard for a corporation to have good faith and act in a prudent manner with regard to these kinds of decisions. And of course, if there's a legal question with regard to a decision you're going to make, then the in-house counsel or outside counsel is there to assist you to make that decision and help make an informed decision about whether or not this is going to be something that's going to be a legal liability for the company. Outside of that, of course, you can't just go to counsel and say, hey, is this a good business decision for us, right? They may not be able to make that decision for you. But they can encourage you to get a consultant or an outside expert that can then, write a report or give a briefing to, the shareholders or to the board of directors before you guys make a decision on it.
Yeah. Like a feasibility study, right?
Right. Like a feasibility study. Hey, these are the potential benefits, consequences, those kinds of things. And then, of course, outside of that, with LLCs, you have a little bit of a different standard, right? With a corporation, your standards are written into the statutes. In Florida, it's under Chapter 607 of the Florida statutes. For LLCs, it's under Chapter 605, and they have a very comparable, and the common law has said that it's analogous standard, but they can drop that fiduciary duty down to gross negligence. And there's some legal cases that are starting to imply that gross negligence, which is a lower standard than willful misconduct, essentially, or willful intentional acts that are in bad faith, could be applicable. So when you have such a lower standard, you probably don't want to be asking legal counsel and disclosing all of your guts to them when it comes to an LLC at the very least.
Yeah, right? Of course.
But ultimately, as counsel for a company, we have a responsibility to the company and their shareholders, not to the officers and the employees. Right? So if there's a question about whether you made a really big mistake, you may not want to be disclosing all of your guts to corporate counsel, which has a fiduciary duty to disclose it to the rest of the shareholders, the chairman of the board, those kinds of things.
Oh, wow. So that could be a mess.
That's going to arise, give liability, give rise to liability to the company.
So I guess that's, that kind of plays my next question, the litigation trends, right? So the trend is, kind of maybe describe that. Can you elaborate on that a little bit more? How common are these lawsuits in general, based on your experience? Yeah,
I mean, we have them, I guess it's more popular in associations, to be honest, and then high level corporations. So there's small and medium-sized businesses where there's a lot of claims that are possible, but not necessarily super common. Again, that's part of the benefit of the business judgment rule is that it gives you the presumption that you made the right decision as long as you're not doing things crazy. Right?
So what do you think of this? Now, you may not know the answer because I'm popping this question up. It just came up in my head. It just popped up. So I'm an LLC member. Say I have a 50-50, meaning we each own 50-50, and I decide that we get a company credit card and we get points on that credit card. And I have a family vacation coming up, and we really don't travel for work, and I decide to use those points for my personal travel. I don't disclose that to you because I think this is a very common thing. The reason why I'm bringing it up, it's not just, I've never done that personally, but I think that this happens all the time. And another business partner finds out or a shareholder finds out that you're using those rewards points for personal travel, not business travel. That's a corporate veil thing, but could that be considered part of the business judgment rule? Or could somebody come after you for that under the business judgment rule? Does that make sense?
Yeah. So first and foremost, I would ask if you were my client and you came to me and said, hey, I think I might have breached my fiduciary duty. The first thing I'm going to do is ask you if you have an employment contract, right? Yeah. Because you could be a managing member and have an employment contract or an operating agreement that authorizes you as part of your compensation to essentially accept these rewards points in order to perform these travel expenses on your own.
That's smart. So
as long as you're claiming it on your income tax, then you should be fine.
I think they got somebody. I don't know. I can't recall the case, but I remember reading it something maybe on like one of these news websites where one of them, and that's actually what made me come up with this question because I was thinking about that article. Was this person spent a bunch of money on their credit card, and in the ordinary course of business, they didn't spend on their
business credit card.
Business credit card. Their business credit card. They didn't spend any money on their personal stuff. It was just all business expenses, but they were receiving a bunch of rewards points. And the partnership kind of went sour for whatever reason, and they actually used they went through the discovery process about what happened and what was going on, and the other partner basically found out that this one person used their points to travel with, and I think there was some sort of issues there with the business judgment rule and also fiduciary duty, and they were able to, I think, pierce the corporate veil. In that circumstance. Now, there might be more underlying issues there that I don't know, but I read this article several years ago, so I don't know if I'm right in explaining that.
Yeah. So what I want to let's talk about the rewards points in general.
Yes.
Okay. So if you're an entrepreneur and you're using reward points, this is what you need to know.
Okay.
I'm not giving you legal advice or tax advice, but this is generally something you should be starting to think about.
Yes.
Okay. Number one, Rewards points, when you start using rewards points from a business and use it for your own personal gain, that can be considered a taxable event, right? Because now you're receiving compensation that you didn't have from a company that you're working for before, and therefore the value that you're receiving is something you need to be claiming on taxes.
And isn't that crazy that you have to pay taxes on that stuff? That's nuts.
Consult.
It's just so
Talk
crazy.
to your CPA, tax attorney.
It's nuts.
If you're ever not sure about how to claim that kind of stuff.
Yeah.
Number two, if you have agreed with another member of yours or other members or shareholders that this is something that you're permitted to do, get it in writing.
Always in writing.
Right? So if you're going to be able to use the business credit card rewards points for your own personal stuff and has nothing to do with the business, then get it in writing.
That
Make
happens.
Sure that it's
Yeah.
disclosed, that you have a resolution, that the directors are authorizing it, and you're good to go.
So I wonder if you should put that, like if you're speaking about an LLC, I wonder if that should just be in the operating agreement.
It is something that you can put into the operating agreement. And this is something that is important for people to recognize.
Yeah.
When it comes to corporation, your bylaws are only going to be able to modify a little bit of your fiduciary duties, but otherwise it's all based off of statute.
Yeah.
Okay, for the most part. When it comes to LLCs, it's a newer creature that kind of came in the late 70s and early 80s that the courts are, allowing us to treat a little bit more like a partnership in some instances, which means you can create whatever rules and waive certain fiduciary duties that you wouldn't be able to waive in a corporation.
Ah, okay.
So
that makes sense.
It's important if you're going to be doing stuff like this to let your attorney know at the outset, hey, I've talked to my partners about this stuff. I know that I'm going to be spending a whole bunch of time, let's say 60, 65 hours a week on this business. And everybody's agreed that because I'm doing all of this extra work, that I'm entitled to keep all the rewards points for my own personal stuff.
Interesting. So
Sure, we can put it into the operating agreement.
Yeah.
And then you're good to go. Now, outside of that, if you don't have an operating agreement, you don't have a resolution, you've never presented it to the shareholders, and you're not using anything for the benefit of the business, right? So let's say you're using your rewards points to go to Belize,
yeah.
right?
Yeah.
For your own personal vacation, and there's no nexus to any kind of business, then you're not going to get the benefit of the business judgment rule.
Interesting.
Because it's not something that's in the benefit of the business at all. It's for you personally, which is a breach of your own duty of loyalty.
Plus, that opens up a can of worms for taxes and stuff. So this brings me to an important point, and I always stress this when I'm helping people start their own businesses, when we're planning whether transitioning from an employee role to like an entrepreneur type role, is everybody says to me, or not everybody, but a lot of people, many people say, why would I spend $1,500 on an LLC and an operating agreement, kind of like a formation package, when I can go to like one of these DIY websites? I'm very anti-DIY when it comes to legal context, because I've learned hard lessons with that.
Right.
And I think a lot of other people have. But this is the most important part of why you hire an attorney to incorporate a company and do your bylaws or operating agreement, because not only can they explain this to you in ways that you understand, but they can help you protect you from those liabilities, like the business judgment rule, and where you're, maybe you have rewards points. Because I don't think one of these DI websites is going to have a clause in their operating agreement that says, hey, this person, in the event that they have rewards points, we're allowing them to use those rewards points for whatever they want to use, right? And I guess that's where good policies come in. And as I become more experienced as an entrepreneur, and as an entrepreneur, you're always learning new things, right? Now I understand. It took me to the age of like 37 or 38. I'm 40 now. Now I understand the importance of policies and procedures and basic business planning, right? Like, I'm not a big fan of like doing this huge, encompassing business plan, but I do understand the importance of like doing, an objectives and summaries and so forth, and policies and procedures, because again, I working with you as an you're an attorney. I see what goes on. I'm like, oh my God, like I need to protect myself as well, just by talking to you. So I think it's really important to, understand what you're doing and how to do it. And that brings me to the next question, is for training. Do you think it's beneficial for companies to train their directors and officers and maybe some senior level managers on the business judgment rule and maybe, fiduciary duty and so forth?
100%, right? I think we get it lulled into this false sense of confidence because of the business judgment rule, thinking that no matter what, you're going to be protected. For example, right, you can be a director and say, well, before I become a director, the only way I'm going to do that is if you give me errors and emissions insurance and you indemnify me for any potential claims against me personally, right, as a corporation to the director. But errors and emissions insurance doesn't cover bad faith actions. And so and neither does the business judgment rule. So, as a director or an officer, you want to know when you're crossing the line from good faith to bad faith.
Right?
Because the moment you cross that threshold is when you're out on your own.
And the company's going to throw you under the bus.
This business judgment rule, and you're not getting the benefit of your insurance. You're under the bus, and you're under the bus big time.
So I think this show is really important, this specific episode, because I think with the economy freezing up, we're in 2025, May 2025 now, but this show applies pretty much evergreen, right?
Yeah.
But for this specific, time and place, a lot of businesses are either going out of business. A lot of big companies that have raised a lot of money from a lot of shareholders, whether it's real estate developers and so forth, they're about to take a big hit. And I can just see one of the reasons why I decided to do the show with you today and come up with this topic was because I see the trends, the litigation trends, and also just the financial trends of, you're going to have more business failures probably in the next 6 months to a year than you've ever had. You have a lot of disruptions coming from supply chains, tariff wars, trade wars, whatever you want to call it. So I think now is a good time if you're an LLC business owner, whether it's yourself, disclose it to yourself, have it in your minute book or, somewhere. If you're a director, an officer, a senior level manager of a business that's raised money, make sure you disclose everything. And if you haven't, maybe go review all your information and maybe make one big disclosure. Now is the time to start protecting yourself from these issues because, you could be the most honest person in the world, but you might have forgot to document something. And that's what I'm talking about. I'm not talking about the people that were like actually intently, like we talked about with intent going out and doing bad things. No, I'm talking about reviewing your paperwork and all your agreements and ensuring that you acted in good faith for the company. And that all those things were disclosed to protect you from future liability because people don't realize, they only realize it maybe when it's too late, right?
Yeah. And you might even in an innocent situation, right? Maybe it's you and me, James, and we're business partners.
Yep.
And you and I have agreed that we're going to, you're going to get those credit card reward points. Okay.
Yep.
But we've only verbalized that.
Yeah.
Right. For all I know, I could die and you suddenly get somebody else from my family that comes and stands in my shoes in this company that says, hey, where's the proof that you were authorized to accept these rewards points?
Yes.
Right?
Yeah.
And then if you don't have anything in writing from me,
happens
and
all the
verbal
time.
Agreement,
yes.
I mean, that's not going to be good for you.
Well, this is what we talk about all the time. Everybody says, well, why do you still do contract? We've been entrepreneurs together for, 15 years, right? From the very beginning of our relationship, so to speak. We've been, doing business together for a long time. So I think it's really important, even if you trust somebody, like you just said, or even if you have a really good working relationship, like we have high trust, I think, and we have a very good working relationship and business relationship. But we still document stuff because like we always say, I'm not worried about you or me. I'm worried about what comes after you and me. Right. And vice versa. If I die from maybe I'm at work and I die or whatever, my family members, my heirs can step into my shoes and make your life a living hell, so to speak, right? They could tie you up in court. And then you're already dealing with the pain and loss and suffering of me, and now you have to deal with the pain and loss and suffering of your business and all these other nonsense things that happen.
Yeah, I've seen quite a few businesses completely go insolvent.
Yeah,
that wouldn't have gone insolvent just because somebody else came in and was saying, "I don't like anything that's going on here. To me, it looks like you've breached a fiduciary duty. I'm going to sue you."
Yeah, and when people die and there's money involved, people get really weird. I mean, and I've seen it happen even in my own professional practice. I see this happen all the time.
Greed and grief.
I get calls from people saying, hey, I need business help here. I need business help there. And then you go in and it's like, wow, this is crazy. I can't believe somebody would do this. This is why me and you always document whatever we're doing, even together, right? The chance of something happening between me and you are rare.
And if you forget to document something, go to an attorney and get the proper paperwork to get it
proper
ratified.
procedure. Yeah, and then follow the proper procedure. So I think the takeaway from this episode, my takeaways would be, always disclose, even when in doubt, disclose, right? Obviously, you can rely on, consultants, lawyers, accountants, experts, so to speak, to protect you or limit your liability, I should say, and help you make proper, informed decisions. The second thing is documentation. I think the third thing would be don't use a DII website for your operational agreements, your bylaws, your resolutions, stuff like that. Because I think personally those open up a lot more liability to long term. You might save money short term, but really you're not saving any money, right? It's like eating a bunch of fast food. Yeah, sure, you're getting cheaper food overall and it's quicker, but long term the consequences are catastrophic. Your health fails, you get chubby, you get fat, whatever, and you have health problems. So I think that's another important factor. And I think making sure you have all those crossing your T's and dotting your I's.
Yeah, and one of those things I would like to add to that is bring in experts. Right?
Yeah,
I know that small businesses, medium-sized businesses, we don't necessarily have the budget to spend a whole bunch of money.
And that's
on
the
somebody
problem
coming in.
Yeah, that's the problem.
But if it's a big decision, you're going to be spending maybe 70% of your working capital on this new decision. It may be worth it to bring somebody in who really knows what they're talking about to give a presentation and actually for you to pay attention and ask questions, right? When it comes to litigation over breach of fiduciary duties and whether or not people are afforded the presumption of the good faith and fair dealing and the business judgment rule, a lot of times did you talk to an expert who knew about this stuff before you decided to spend all this money on this? And how long did you actually spend in that meeting? Did you pay attention? Did you ask questions? Did you take notes? Or was it just a 5-minute meeting where somebody said, "Hey, we're all going to be rich," then walked away, right? And everybody approved it, right? Which has been cases in the past.
Yeah. Don't do discovery on me. You're very smart when it comes to these questions. So, I guess. What would one tip if you had to leave today and you had to, we're done for the show today? But what would one tip be? What can you give somebody one tip that would really help them out in this situation?
Yeah, I think honestly, number one is do your research, right? Use common sense.
So that means like printing, like if you're doing research online about a specific subject or a decision you're about to make, when you're visiting the website, print that, off or save that in some sort of PDF file and call it like, XYZ business decision. Is that what you're saying?
Well, what I'm saying is imagine yourself a year from this date before you made this, after you've made this decision, having to fight a lawsuit from a shareholder who is your worst nightmare, who really has it out to get you, like that shareholder who's going after Elon Musk.
Which is crazy. Yeah, I think he wants like $6 billion.
So imagine that situation. What would you want to be able to say on the stand or in legal documents to justify why you made that decision? Right?
That makes sense. Actually, that's a good way of looking at it.
What would be a really good explanation to tell the judge or the trier of fact as to why you made this decision in the first place? It would be great if you could turn around and say, well, I called in an expert who gave a presentation. We had 3 hours with that person. We drilled down. We asked him all these questions. We understood all of the potential consequences. And despite all of the potential consequences that were disclosed to us, we thought the benefit to the company outweighed the risk. And therefore, we made this decision. It just ended up that the consequences end up being the one that weighed out.
It didn't work out. So I guess this kind of, when a big company is maybe buying another company, like an M&A type transaction, that's why they have all these consultants and legal professionals go through all the contracts and so forth. I remember a situation, this happened to me, what was it, 2006 or 7. I remember when I first started my venture capital company and we acquired this debt management business, I had a lawyer do a bunch of due diligence, and then everything was good. We acquired the company, and then we were about to do what we call reverse takeover or reverse merger into another company. And I remember paying this guy like this is a lot of money back then. It was like $750 an hour. I'm like, oh my god, I got a bill for like $15,000 after this meeting, but it was well worth it. I'm glad now looking back that I spent the $15,000 because I remember in that meeting, the guy had like flow charts and percentages and this and that and all these different scenarios. And he actually said to me point blank, he said, don't acquire this company. This is a bad deal for you. And I look back now knowing what I know about the business judgment rule. And I'm glad I made that decision not to acquire the company, even though I wanted to so badly acquire the company because it was my dream at the time, to have a publicly traded company, not my dream anymore, but was have a bunch of shareholders and be like a wheeler and dealer and moneymaker, right? And I remember leaving that meeting so disappointed, and I was even more disappointed when I got the legal bill and I had to pay the 15 or whatever, 20. It was a lot of money.
Right.
But now looking back, hindsight's 2020, I'm very happy it happened because I think if I would have acquired that company, it would open up a can of worms. And like I said earlier, I know this is weird when people hear it, but it's kind of funny when I say to people, I've never been sued by a shareholder. That's really important. That's like a badge of honor because that means that you've done things right, generally speaking,
Or you've
right?
been really super lucky.
Lucky. Yeah. No, I'm not. I'm very transparent. That's my biggest disadvantage, I guess, in my life.
Well,
is
listen,
I'm too transparent.
you can be 110% transparent
Yeah.
and an honest
Yeah.
person and work in good faith, and you
Yeah.
can still be sued by a shareholder.
Yeah, that's the whole point I'm trying to make, right? Is that's, it happens all the time. And you get what I call professional takers out there that will literally, if you're a publicly traded company, they'll buy one share for like $3 or whatever your shares are going for at the time. And they'll launch a derivative suit. And then they basically, they don't necessarily want to see you go under or out of business, but they want a settlement. They want you to quiet them, so to speak.
Right.
So then you have to do all these deals and it just costs more money long term. So, I'm a big believer in fighting, right? So if somebody comes after me and says, hey, you did this wrong, I provide the evidence and the proof. Hey, I went to an attorney, I went to an expert, I had a CPA.
I disclosed it.
It to the board. Look at the
wasn't
offering.
Just me who made this decision.
Correct.
It was everybody on the board who had the same information available to them as I did.
Correct.
And everyone was sanctified and approved.
And then you have the right to fight and you'll probably win. And I think that's the most important aspect is making sure everything's documented. And when you're in doubt, always check it out, right? Yep. When you're in doubt, go see an attorney, get that legal opinion that you want, an accountant, an expert, and then you should be generally fine, I would think.
Yeah, I mean, and again, getting back to that other question that you had before about whether you talk to the company's attorney or your own personal attorney, right? That's going to depend on the ins and outs of the decision, right?
Of course.
So the company attorney is there to make sure that the company's making the right decision. So if you're concerned about the legal implications of having made that decision, then go to the company attorney.
Of course.
But if you're concerned about whether or not you can make money on the side from this business and what kind of disclosure you need, when it's kind of outside of the scope of whether it's a legal implication for the company rather than for you, then definitely go see your own attorney.
Of course, yeah. So personal attorney and then a corporate attorney or something like that. Okay, that makes a lot of sense. Well, that's our show for today, Andrew. Thank you for coming in again. And we look forward to our show next week.
Yeah,
Have a great day. Yep, bye-bye.